Hello, I'm adventure journalist Jamie Moy, and this is the Core Outdoors Speaker Series. Once a month, Core offers this free online webinar to inspire and share valuable information in the outdoor rec tech space. Today, we'll be hearing from Pablo Tseng, a partner with McMillan LLP. Pablo is an expert in intellectual property law. He'll be introducing two new government initiatives that can help rec tech businesses make the most of their innovations. And he's keen to answer any questions you might have about intellectual property in general, or how to better leverage your company's innovations. I'm going to turn this over to Pablo, but I wanted to mention that instead of holding your questions until the end, just type them into the chat as we go. I'll be watching the chat and compose them to Pablo. It's just more fun and interactive for everybody. All right, Pablo, the floor is yours. If you could go ahead and please share your screen.
Well, thank you very much, Jamie, and thank you for inviting me to speak with the core members. I'm actually very happy to be speaking with core members and just talking about IP. It's what I do, and it's how I just like to share about what I do and how it might be relevant to your business, and when you encounter situations, what you might want to look out for, and how you can take the next steps towards protecting what's valuably yours, your intellectual property. So I've prepared a slide deck that I'm going to share. Bear with me. Now, Jamie, can you confirm that you see my slides?
Yep, I can see them. Thank you.
Wonderful. All right. So as Jamie mentioned, we're talking about, or I'll be chatting about two government programs that have been going on for about over a year, and certainly want to introduce you to them, as they certainly do relate to how you can better protect your intellectual property, both from developing a strategy for how you might want to protect your IP and actually implementing and taking the steps to file the applications that you want to file. Now, before we dive into it, I'll take this opportunity to just briefly introduce myself, and so I'll skip to this slide. So I'm a partner at a law firm called McMillan LLP, and McMillan is a business law firm, and meaning that we basically cover all legal services related to a business from start to finish to exit, a component of which is intellectual property. And so my area of focus in the legal arena is strictly intellectual property. And intellectual property, of course, is an umbrella term that covers off a number of sub-disciplines. And you may have heard of these disciplines such as copyrights, trademarks, patents, industrial designs, and trade secrets, as well as others. Of these sub-disciplines, my particular focuses are in patents and trademark work and general commercial IP work, such as licensing and transactions. Yeah, so on the patent side, for example, prior to law school, I was a chemist. So a lot of the patents that I draft are related to chemical inventions, and mechanical devices. And so you will quickly appreciate that on the patent side, you will have different sub areas, and you may go to different service providers depending on the technical area that they are comfortable with. In my case, chemistry and simple mechanical devices. Now, scrolling back to the agenda that we'll be going over today, as mentioned before, we're going to be focusing in on two government programs, which you may be already familiar with. One of them is the NRC IRAP program, and the other one is Elevate IP, or known as in British Columbia as Accelerate IP. And the Elevate IP program itself is covered off, or it spans well, both of these actually span are across Canada and rolled out across Canada. But for Elevate IP, depending on the province that you're in, it may go by a different name. And if you come across terms like Elevate IP, Accelerate IP, Accelerate IP is really just a subset of the Elevate IP program. Now, I'll first chat about the IRAP program before shifting gears and to talk about the Accelerate IP program. You will notice over the course of this presentation that there are a lot of similarities between the two programs, and there's a lot of overlap. And this kind of overlap can only benefit a small medium enterprise as you embark on your journey of IP protection. And just as a heads up, just because you're currently working under one particular program does not preclude you from applying for the other program. And so a lot of the clients that I've been working with actually work in both IRAP and Accelerate IP and have received funding from both sources. And so we can chat more about that later. But a takeaway for you is that these programs, they're not exclusive. And in fact, you are encouraged to seek government funding and apply for this government funding from both programs to maximize, your ability to protect your IP, both domestically in Canada and abroad. So more about let's chat about the IRAP program. The IRAP program is administered by the National Research Council, and IRAP stands for the Industrial Research Assistance Program. It operates the IP Assist program, known as IP Assist, and the IP Assist program is specifically designed to help SMEs commercialize and safeguard their intellectual property developed in Canada. Now, access to this program is typically gained by referral from an industrial technology advisor. So you are working with an NRC advisor who will help you, review your business strategy and your IP needs, and then make a recommendation accordingly as to whether your business would benefit from the IRAP IP Assist program. The IP Assist program is broken down into 3 separate levels, and the general hope is that you will move on to the second, or you advance, past, onto the next level after you've completed the previous level. So most people start off with entry into the IP Assist program at level 1. Level 1 is simply just an awareness program. It's up to, you get to spend up to 3 hours with a practitioner, such as myself, to enhance your knowledge on the basics of intellectual property. So over those 3 hours, an IP practitioner would give you a high-level overview of what's covered under intellectual property, what the sub-disciplines of intellectual property are, and then briefly go over how that relates to your business. You'll quickly, if you've done it or if you will participate in level 1, you'll quickly realize that 3 hours actually flies by very quickly. So the amount of information that you'll extract from it, or the benefit of it, is really just from gaining a high-level overview of what exactly IP is and taking that knowledge and figuring out how that applies to your current business and what you might be developing that could qualify as IP that is worth protecting. Now, after you've completed the level 1 awareness, and after thinking it some more and discussing it with your ITA, that you actually have some intellectual property, or that you want to further refine or develop a roadmap on how to protect your intellectual property, then you would move to level 2, which is strategy development. And so the purpose of this strategy development is to help you, your business, assess what exactly you have in terms of intellectual property. Service providers like myself often see that businesses don't know what they actually have, or they make assumptions about their assets that are not always accurate. And so as a part of the strategy, what you will get out of it is an IP audit, a review of the intellectual property assets that you have, and then from there, help you categorize what you have into different buckets of copyrights, trademarks, patents, industrial designs, and trade secrets, thereby giving you a very good overview of what exactly you have on IP and what kind of intellectual property it really is. This is particularly important for those that are developing new products or refinement to new products. And what we often see is that those that are doing these refinements day to day as a part of their work overlook at times the inventiveness that they actually do bring to the table when they're actually making those refinements or modifications. And the purpose of that IP audit is to help those inventors and workers take a step back and help them appreciate that what they're doing, although it appears to them to be quite obvious, really isn't, and they from a isn't obvious from a legal standpoint, so that they might consider actually seeking protection for whatever modifications or enhancements they are making. So that's so the strategy covers off the IP audit, and if the SME comes to level 2 with actually a with inventions that they've created, the strategy level also allows them to do prior art searches and landscape searches, and if at any time I'm using terminology that you're not entirely familiar with, please pop it into the chat, and I'm happy to explain more about those terms that I'm using, such as prior art searches or landscape searches. But for the purposes of the presentation and for timing, I'm going to use these terms and assume that you understand unless you tell me otherwise. So the strategy allows you to do prior art searches as well as landscape searches, and to an extent also help you identify white spaces that you can potentially explore developing more intellectual property in. On the trademark side, if you come with trademarks, the strategy would what's covered under level 2 will allow you to search for trademarks and make sure that you're using a trademark that is not conflicting with anyone else in Canada or any other jurisdiction that you plan to do business in the immediate future. So the strategy does cover off a lot of searches, just to give you an idea of whether your IP is worth protecting or whether you are actually able to use and commercialize what you think is your intellectual property. Strategy level, so level 2 also covers review of contractual arrangements that you may have already entered into or are thinking about entering into. And things that you might want to review, for example, is if you're in an engagement where you're contracting with a third party to help you modify a particular product, a question will arise. All right, if new IP is generated over that course of engagement, who actually owns that intellectual property? So questions like those and how intellectual property is divided between or amongst the involved parties is what your service provider at L2 would help you review and point out to you where your legal rights actually lie. So after a roadmap has been developed for your intellectual property and you have an idea of how to take the next steps and what steps to take to protect your intellectual property, you can then apply for level 3, which is taking action and executing on that IP strategy. In my experience with IRAP, getting funding for level 1 and level 2 is pretty straightforward. getting funding for level 3 takes a little bit more work and an actual statement of a plan as to what you need to do to execute on your IP strategy. And so, and the application for level 3 is something that you can certainly work with on with your ITA in order to craft that, well, ITA and service provider, in order to craft that statement of work that would demonstrate why or justify why you require level 3 funding. So level 3 funding, at least from the IRAP side, a bit more discretionary, and they do want to see more detail as to what exactly you need to protect and the timeline that you propose that you should be operating on in order to protect your intellectual property. I'd say the IRAP program, in my experience over the past year and a half, has been excellent. Many people go into the IRAP program, or at least some people that I've dealt with, go into the IRAP program with preconceived notions about intellectual property that are either confirmed or they are ultimately, or they ultimately realize isn't accurate. So at least from an awareness standpoint, and having that, sit down with an IP practitioner, the feedback that I've received is that it's invaluable, and it at least helps them orient their thinking as to how to better, build value for their business. And then for those that actually are developing intellectual property, having that roadmap as to what they should be doing and also should not be doing and should not be focusing on has at least the feedback that I've received helped them budget better when it comes to what to protect and what not to protect in terms of intellectual property. So I'll just pause here for before I move on to chat about AccelerateIP. So AccelerateIP is another government program that the government of Canada has rolled out, and specifically ISED. So this is the Department of Innovation. I think it's Innovation, Science, and Economic Development. So ISED is rolling out the Elevate IP across Canada. Depending on the region that you're in, you will be dealing with a different organization. And so the Elevate IP program has been broken up into 5 geographical regions. So we'll start from east to west. Out in the Atlantic and Maritime provinces, you would go to Springboard Atlantic as your main organization to interact with for the Elevate IP program. In Quebec, it's Maine. In Ontario and Manitoba and Saskatchewan, you'll be dealing with Communitech. In Alberta, you'll be dealing with Innovate Calgary. And here in British Columbia and the territories, you'll be dealing with New Ventures BC Society. And in British Columbia, we don't call Elevate IP. Instead, we call it AccelerateIP. So it takes, as you can appreciate, it takes a lot of collaborators and partners and organizations to help make the AccelerateIP funding program a success. And depending on your geographical region within British Columbia or the territories, and depending on perhaps the subject matter or the industry that you're in, you may be chatting with or interacting with different partners. So on the left-hand side, we have various partners that are committed to rolling out the AccelerateIP program. And of course, Kamloops Innovation Center, Kootenays Association for Science and Technology are one of the partners of AccelerateIP. And my understanding is that companies could be dealing with multiple partners. So it's So just because you're dealing with CAST doesn't preclude you from dealing with another partner, particularly if your business spans various regions across British Columbia, or has a specific industry focus. In which case, you may deal with an organization, a partner based on your geographical location, but deal with another partner based on your industry experience or industry expertise. Working alongside the partners are a number of collaborators, which helps get the word out for Accelerate IP, or helps intake companies and introduces them to service providers like myself. So yeah, this list is just intended to show that there are a number of people working together in order to roll out the Accelerate IP program. Now, the structure of the Accelerate IP program is very similar to the structure of the IRAP program. You start out with an awareness, so gaining some basic education about intellectual property. You follow that up with some strategy development, creation of a roadmap of how to protect your intellectual property. The addition that Accelerate IP brings to the table that IRAP doesn't outwardly have is this mentorship. And I say it outwardly because, at least per the Accelerate IP stream, there's a line item or an actual program that's actually called mentorship as a part of your strategy development. IRAP actually already has that as well, and that's actually your interaction with your ITA. And so while it may not be explicitly listed as a specific program that you can have with IRAP, the fact that IRAP already builds that in organically, and your ITA and someone you work with who themselves likely have a lot of business experience and can provide you very good insight from a business perspective as to what to do, what to focus on, and how to build a business. So both programs do have a mentorship component, but just packaged in a different way. Both programs have that strategy development program or stream as well. In Accelerate IP, it's known as Stream 2-2. And similar to IRAP, it covers off things like IP audits, competitive analyses, IP landscape analyses, FTOs, which are freedom to operate analyses, prior art searches, contractual review, and template generation, as well as an out-license, in-license strategy and trademark and branding strategy development. Pause here because I realized I didn't talk about costs or funding that you'll receive from IRAP. So let's see. Nope. So skipping back just a couple of slides. For the awareness level 1, my understanding is that the SME doesn't need to pay anything, and that just through their engagement with an ITA and the ITA's recommendation that the IRAP IP Assist program is appropriate for them, that the SME would be allotted 3 hours with an IP practitioner on the house from the SME's perspective. Level 2, I understand, is that the SME would need to contribute $500 for the strategy development. In return, the value that they're getting is approximately $18K. So the buy-in to the strategy development is quite low for the SME, thereby making the IP Assist program a very sought after and worthwhile program for the SME. Level 3 is somewhat discretionary and dependent on your actual needs. And so the amount of funding will vary, anything from $5K to as high as I've seen it, about $25K. So very dependent on what you need and what IRAP will invest in. because as you can appreciate, these programs are not doling out free money. They are making an assessment as to the potential viability and commercial value that your business may bring to the greater Canadian marketplace and abroad. So keeping those values in mind, I only bring that up because in my comment here, for strategy development under Accelerate IP, you may be approved for about 25K. That's total value, of which you may need to contribute approximately 25% of those costs. So the buy-in from the SME for Accelerate IP is actually higher than it is for IRAP. You will need to contribute about 25% of the total costs of the strategy development. If your business is founded by Indigenous founders, then the buy-in for those companies is 10%, so a little less than those that are not eligible for that co-investment. So assuming that you have developed the roadmap for IP strategy, now comes time to implementation. So implementation it means really drafting that patent application to describe your invention, actually filing an application related to that invention, or drafting the trademark application describing your trademark and the goods and services that it's associated with, and actually filing that trademark application. There's a lot of money on the table to the extent that you're eligible for it, and to the extent that your needs require that funding. Currently, it's up to 60K, and you'll be working with a service provider like myself to help you determine what you actually need to do and what the approximate costs are to doing those specific items. Similarly, yes, the entire funding is up to 60K, but you would need to contribute a quarter of those funds, so you would need to pay 15K, whereas the government would support the remaining 45K. And similarly, it's 25K for companies with non-Indigenous founders, and 10% co-investment for those with Indigenous founders. This is a competitive process, and so that is vetted by a selection committee. So when you prepare that quote as to what you need to do, it's best to prepare that quote with your service provider so that both the service provider and, of course, you are informed as to what the quote's going to be and what action items need to be done and what time frame those action items need to be completed by. So things that are supported under the implementation stream include IP registrations, IP applications, filing fees, the drafting of legal contracts, the drafting of patent applications, the drafting of trademark applications. And these fees aren't just limited to Canada-specific filing fees. If your business also has interests in other parts of the world, we'll say United States or abroad, somewhere in Europe, Stream 3 under Accelerate IP will also help you offset a lot of those filing costs. And for those on the call who have gone through, say, the patent process before and have filed patent applications in multiple jurisdictions, I think you will attest to the fact that costs stack up very quickly depending on the number of jurisdictions you are seeking IP protection in. And so having these government programs, to alleviate those costs has been, at least in my experience, very beneficial to those companies that I've been working with who have IP protection in not just on the continent, but also abroad. So what do you need to know? currently the Elevate IP program has a sunset date of 2026. So we have about 2 more years for this first iteration of the Elevate IP program. That's not to say that at 2026 this program will just disappear. It could, but depending on the success of it or and what kind of traction it's gained, the government may make a further evaluation as to whether it's worth extending the program. Now, at least in this current iteration of it, about $90 million has been allocated towards the delivery of this program across Canada, and a third of which is allotted to Western Canada. So there's good about $30 million on the table for BC and the territories, and that is why with this funding we do encourage SMEs to capitalize and apply to this. I mean, this is a program that's designed for you to help you accelerate and your ability to protect your intellectual property, not just domestically, but on an international scale as well. And so it's something that you should certainly keep in mind for this, for your IP journey. Of course, there are certain criteria that you'll need to satisfy in order to be eligible for Elevate IP. And this is very specific to the region that you're in. So different geographical regions. So if you're out in Atlantic Canada or you're in Central Canada, their criteria for receiving funding will be quite different from what it is out here in British Columbia. So, for example, bullet point 2. Many programs only support privately held companies, so companies that are not public or that are not publicly trading their stocks or their shares, which is a lot of companies, most companies in fact. Accelerate IP, however, is actually open to public companies as well. So to the extent that your company is actually already publicly traded on a stock exchange, whether it be the CSE or the TSX or the TSXV, Accelerate IP doesn't really care, and so I've had the pleasure of actually working with a couple of publicly traded companies who have gained funding through the Accelerate IP program. But to my knowledge, that's only Accelerate IP. So if you were elsewhere, say in Ontario, for example, if you were a public company out there, my understanding is that you wouldn't have access to Elevate IP funding, and that Elevate IP funding out there is only for privately held companies. Many companies also, or sorry, many programs or organizations that administer the program will also require information about the financial status of your company. So if you're making a lot of money already, revenue generating by the millions, if you exceed a threshold amount, then you would not be eligible for funding. The funding really is intended for SMEs to help them get a kickstart towards protecting their IP, to help them help level the playing field essentially between SMEs and more established companies. So if you are fortunate enough to be raking in a lot of money and revenue already, then this program is probably not right for you, and please do not apply because you're already financially well off. The other thing to note about the Accelerate IP program, similar to IRAP, is that the service offerings from the IP perspective is very comprehensive. You get strategy development, implementation work, IP protection, and even IP contractual work. Now, things that are not IP related would not be covered under Accelerate IP or IRAP. The focus here is your intellectual property. It's not designed to help you with mergers and acquisitions or helping you structure or restructure your corporate organization. The focus is IP and IP only, whether it be IP related to employment agreements or whether it be related to actual protection of your intellectual property. Now, as mentioned before, companies can double dip. You can work with IRAP. You can also work with Accelerate IP or the broader Elevate IP program. And if you count all the dollars and cents and quickly tabulate it, yeah, if you have a lot of IP work to do, you could very well close in on about or have access to about 80 to 90K in funding, which is a very good chunk of change to get you started and on your IP protection process, and in some cases to complete it as well, depending on the amount of IP that you need protected. So it's no small amount to sneeze at, and at least in my experience, those that have gone through both, well, either the IRAP or Accelerate IP program or both of them, have had nothing to say about the benefits they have gained through the program, both from a learning experience as well as from a strategy and development and implementation standpoint. And of course, who can you work with in this program? So for the Accelerate IP program, the service provider that you'll need to work with has to be vetted by New Ventures BC. So New Ventures BC has a roster of service providers that are eligible to deliver services. My firm is a vetted service provider. There are other service providers out there as well. And so it's important to work with the vetted service provider, because otherwise, it's not that you can't work with a service provider that hasn't been vetted, but it's just that if in that case, that service provider would need to be vetted before they can actually be compensated for the work that they deliver. So that is the, I guess, a brief introduction over about both these government programs, the IRAP program as well as the Accelerate IP program. I encourage all of you to apply for it, or to at least inquire about it and see how it fits into your business strategy. And of course, although I was here predominantly just to talk about these two programs, I'm also more than happy and willing to discuss or chat about general IP topics that you have on your mind at a high level. I mean, definitely won't go into specifics, but at least high-level feedback I'm more than happy to deliver as part of the Q&A. And so I'll pause right there. I'll pass the floor back over to Jamie, yeah, more than happy to engage in dialogue from here.
Thanks so much, Pablo. That was some really important information, and also kind of a lot to take in. So I'm wondering if there are any questions on the floor. I've got one coming in from Jean-Francois.
Mm-hmm.
So he's curious what the time frame is between the initial consult and the completion of registration for an SMB without one product that they're trying to protect.
Yeah. So within so both programs operate on very similar timelines. The educational component is supposed to be completed within a month of initial engagement. And so the goal of these programs is really not to drag out to drag out the process. And so the service and so the companies in like say Innovate BC or the organization that administers these programs on behalf of the government really do crack the whip and make sure that both the service provider and the company are abiding by their timelines. So yeah, level 1 education. Yeah, you should probably allot about a month to complete. And then soon thereafter, if the companies are eligible or are appropriate for strategy development, then the turnaround time for IRAP is actually fairly quick. I've seen turnaround times of a week. I've also seen turnaround times of a month, basically from completion of L1 to the granting or approval for L2. So that timeline seems to be dependent on how quickly, I'll speak for IRAP right now, how quickly the company works with their ITA to get that approval. So be in good dialogue with your ITA if you plan on getting IRAP funding. On the Accelerate IP side, for getting Stream 2 funding, my understanding is that Stream 2, which is the implementation, which is the strategy development side, they take applications on a rolling basis. Right now, I've seen approval periods of anywhere from 3 weeks to about 2 months. But that one's taken in on a rolling basis. So so once you've completed the educational component, whether it be with IRAP or from Accelerate IP, make that application quickly, and so that you're in the queue. My understanding is that they review the applications in the order that they are received, so the quicker the better. Now, in terms of completing the actual L2 or Stream 2 engagement for the strategy development, SMEs are given 3 months to complete. And this is, completion of your IP audit, completion of your competitive landscape analysis, completion of your contractual reviews, and other items that are covered within within that strategy development. Is 3 months a fixed deadline? No, it's not. But if you're dragging out the process to 5 months or 6 months, you will probably not be able to do so. Again, the purpose of both of these programs is to move you along and not to drag things out. And this is both from a practical standpoint in terms of how they're budgeting their resources, and of course, no IP strategy should really, be dragged out indefinitely. You want to have it developed in a succinct time period so that you know what to do in either the coming months or or next quarter of the year. Now, after you've completed the Stream 2 or L2, then it goes to L3 or Stream 3. L3 for IRAP, Stream 3 for Accelerate IP. For IRAP, again, the turnaround time from L2 to L3 depends on how quickly you are coordinating with your ITA and how quickly you create your submission for this funding. Again, for IRAP, I've seen turnaround times from anywhere from 3 weeks to about a month and a half. So they're pretty quick in their review. And once they grant you some funding to implement your IP, you're given a 3-month window to complete the process. If you cannot complete the process in 3 months, so say, for example, 9 months from now, you have another patent filing that you must do, then my understanding is that you are encouraged to reapply in advance of that action item, and hopefully secure funding for that. My understanding is that both IRAP and Accelerate IP is that you can't hold on to your funding indefinitely. So you have to use that funding within a discrete period of time, after which the funding is basically released to other people that need it more on an urgent basis than you. And when you require funding again, then you just make a separate application to receive additional funding to complete the tasks that you need to complete. On Accelerate IP for Stream 3, applications are taken are at fixed periods of time. So it's not received on a rolling basis. I believe that Accelerate IP just wrapped up their intake process that ended April 30th, and that they are doing another intake process over the summer. So watch out for those deadlines. Get in contact with New Ventures BC, who is administering the Accelerate IP program in British Columbia and the territories. Get in contact with CAST to get insight. So basically talk with the partners and talk with New Ventures VCs to figure out that you're meeting their deadlines and that you're submitting what they need to review in order to make an assessment of whether you'd be eligible for their funding. Now, if received, the Stream 3 time period allotted is anywhere from 3 months to 6 months, depending on what you actually need to do during the next quarter or the next couple of quarters. And again, if you need more money after that period of time, reapply, but the funding won't be held for you indefinitely. So I hope that answers the question in terms of timelines and what needs to be done and how you need to reapply in the event that you have more work that needs to be done.
Thanks for that, Pablo. One thing I was kind of wondering is oftentimes, well, maybe this is just my perception, but you're spending a lot of time with these types of programs on the reporting, almost as much time as you're spent working on your business. Do you have a sense for what the reporting protocols are like for these different streams?
Yeah, so some of the reporting is not, my understanding, at least from the clients that I've worked with, it's there is some work, but it's not necessarily onerous. There's somewhat, I'll say it's somewhat of a checklist, right? They'll see like, have you done this? Have you done that? But as to presentation of what the actual strategy is, and whether you need to deliver like a final work product and a summary of what you discussed with your service provider, my understanding is that it's not always the case. I mean, they would like to make sure that you've done something and that what you've done makes sense, but it's not. My understanding is that it's not an overly onerous request. What is more onerous, of course, is your preparation for the application, as you would expect, right? I mean, government's not giving free money. They want to make sure that they are allotting their resources appropriately for the companies that need it the most and that have potential to benefit the Canadian economy and to put Canada on the map in terms of IP development. So that initial application, as you would expect from any application for government funding, sure, you can call it onerous, but at the end of the day, you're also getting a good chunk of change in exchange for that sweat.
Great. Well, just a couple more minutes here. Anybody else? All right, then. Well, thank you, Pablo. That completes our webinar for this month. The June session will be Thursday, the 13th at the usual time. Oh, we've got one more question coming in here. Question, how do you suggest a startup company that is incorporated in the US, Delaware, that is a Canadian company, access the funding?
Yeah. So for those, if you are working with an ITA, then chat with your ITA about that. My understanding is that some companies have set up subsidiaries in the region that they want to access government funding. So let's say British Columbia, for example, you want to target AccelerateIP. Some companies have established a subsidiary in British Columbia. And because they already have boots on the ground in British Columbia, notwithstanding the fact they may have been Delaware incorporated or incorporated elsewhere, they would qualify for that. I think the standard here is that you have to have a real and substantial connection to the geographical region that you're seeking funding from. If you don't have that, then I would say that you're out of luck in that the funding's not right for you. This isn't something that you want to force. It's got to be organic. So if you really have a real substantive connection to British Columbia, then that wouldn't be a problem. But yeah, if you're over in, let's say, the UK, and now you're trying to access AccelerateIP, and all of your operations are in UK, where AccelerateIP is probably not interested in funding such companies. Yeah. So yeah, so that's one way to go. Set up a subsidiary, but more importantly, you have to have some sort of connection to British Columbia or the territories.
All right, so I was just saying June 13th for the next speaker series. Look for more information on that speaker coming soon. Also, registration for the 2024 Core Summit goes live tomorrow. So that's the annual in-person event, which is going to be held this year, October 3rd through 5th in beautiful Kimberley, British Columbia. And the early bird pricing will be in effect until June 30th. So definitely hit the Core website starting tomorrow and get registered. All right, I'm signing off the meeting. Thanks again and see everyone in June.